on YouTube as well. Okay, now we're live. Welcome in, everybody. So today's sessions, let me briefly share my screen. We'll be focusing on the H1B lottery and change it, joining us from the West and the East Coast of the US. And then let me just start sharing my screen, and then while everybody could settle in and join today's session. So for today's sessions, I think a lot of you have seen different sources of information on social media or on the news that H1B lottery is going through a huge potential changes that might happen in the near future. So what does that mean to an F1, OPT, or CPT background? I'm assuming a lot of students are coming from an F1 background. And then for today, we're going to specifically talk about for the proposal itself, how would it change the H1B lottery in any way. And then we heard that some of the proposal might be related to degree or salary-based changes when it comes to H1B lottery odds. So we want to understand a little bit about the new system, and then what will be the next. So our attorney panel here is also going to talk about rulemaking timelines and rulemaking process of when is this proposal is going to take in effect, will it become effect, and then how could it happen, and then when will be the timeline. So followed by the presentations, we will also have a live Q&A sessions with our attorney panels. So definitely stick around. If you have a live questions, feel free to send them into the Q&A box down in your Zoom. We will kind of see which questions will be applied commonly to the audiences, and hopefully we can address as much questions as we could. All right. Let's get started. Before we do so, I'm going to briefly introduce who we are, why we're here. So we are Go Elite. We're an education consultancy. We are the host of today's event. We are specifically focusing on hybrid professional programs, or day one CPT programs, you may call it, for students under OPT who wanted to prolong their work status and study in the US. So we are authorized by ARRC as one of the most respectful education organization in the whole US. Some of the things we have, for example, our community. If you join the community, once you enroll into a school, there's a couple activities you can do, and you can join student groups and learn more about the communities. And then also we have weekly webinars just like this one. So if you're interested in learning more about F1 visa, immigration laws, immigration proposals, or other things like Day 1 CPT, feel free to go to goelite.com/events. You can sign up for more events to come. So we're also on Google reviews and social media channels. So feel free to check us out on all channels. And without further ado, I will stop sharing from my end, and Marta will go ahead first and present on her side.
Thank you very much, Ryan. Thanks to Go Elite for hosting today's immigration workshop. Happy to be here. Let me share my screen. Okay. All right, does that work? Okay, all right, great. So I know today's topic is about this proposed rule. What is a proposed rule? I know David is going to cover that later. All right. I'm sure all of you who are attending today's webinar probably have read it somewhere, maybe on the social media, or at least now you've heard of it. Okay, there's a new rule about the H1B lottery. So what we are going to do is to give a little background information. I'm going to talk a little bit about how's the wage level determined in the H1B context, and what this rule might look like. I say might look like because the official copy of the rule hasn't been released yet. We only know it's at the stage very close to be published officially, but we haven't seen the full text yet. There's another proposed rule about F1 status, okay, about the fixed period of status for F1 that's today's published, and it's going to be officially published to the Federal Register tomorrow. But that's a different rule, okay? Don't get confused with that one. This is a separate rule. We're still waiting for the full text to be released. Okay. A little bit disclaimer, as always, today's information is for educational purpose only. It is not legal advice. And today's materials are intended for your own reference only. Please do not share it without any written consent to any third party or on social media. But I know this whole recording will be published on Go Elite's YouTube channel later on, so you can still access later. Okay. A little bit about myself. I am based in LA. I practice immigration law. I've been practicing for 13 years now. I specialize in employment-based immigration petitions, work visas, and deal with F1 status a lot. All right, so this is today's topic. We're going to talk about the current H1B lottery rule a little bit. And we're going to talk about the current lottery, how the process works, and how does the wage level place in the H1B context. Okay. Okay, first, about the H1B lottery. As a lot of you might have already known, there's a cap. There's an annual cap for the H1B visa. So the annual cap is 65,000 for all. We call that regular cap, but pretty much that's for everybody who would like to participate in the H1B lottery. There's another 20,000 H1B master cap reserved for those beneficiaries who hold U.S. advanced degrees. U.S. advanced degrees means master degrees or PhD degrees, okay, or any other like advanced degrees. There's no distinction between PhD or master. We've been asked a lot, like, do I have a better chance as a PhD student? Not really. Compared to the master degree holders, you guys are in the same pool. You get one chance in the regular pool and you get another shot in the master pool, but you don't get extra credit for having the PhD degree. And starting last year, we have this so-called beneficiary-centric lottery system, which means as one person, like an individual, the employee who is being sponsored by the company, you're only going to be counted once in the lottery process, regardless of how many employers you have. Okay, maybe you've heard of stories in the past where one employee have multiple employers like sponsoring this person, right? The person might be sponsored by 10 companies or even more than 10 companies. And then if each registration would be counted once, then that would kind of increase the chance of selection for that person. Not anymore. Right now, it's the beneficiary-centric lottery system. You're gonna only be counted once. So how does that work then? If you have like more than one company who's interested in sponsoring you and they all register for you, well, if you're selected, then they can all file petitions for you. If you're not selected, then none of them are gonna be able to file petition for you. So that's how it works right now. And the lottery itself is purely random. Okay. The only thing that may help with your chance is just a U.S. advanced degree. That's the only thing. And the way it works is everybody is going to be selected randomly under the regular cap first. For those who are unselected and who hold U.S. advanced degrees, you get a second chance in the master pool. Okay, so you're going to be selected for the 20,000 master cap if you're not selected first in the 65,000 regular cap. That's all. It doesn't have anything to do with any other factors. Okay, that's also a very common question. We've been asked a lot. Oh, does that matter? My company is a startup. Does that matter? My school is not a high-ranking school. It doesn't matter. It has nothing to do with any other factors except your luck. Okay. And that actually, like in the media, sometimes that's portrayed as something unfair. How can it be so random, right? Like you cannot give out work visas to foreign workers just by pure luck. Well, that's a lot of confusion there because lottery in the H1B context just means you get a chance to have your petition to be reviewed by USCIS. It doesn't mean you are approved for H1B yet, okay? Just because the demand for H1B petition is so high, for H1B visa is so high, that they cannot decide like which ones to review first. So we have to go through this random lottery system just to pick the ones to be reviewed. Even some of the cases, some of the registrations get selected. It doesn't mean all of them are going to be approved, right? Whether the case is approved or not, that's a different story. That is the actual filing of the H1B petition and the adjudication of the H1B petition. So lottery just means getting a chance to put your file on the desk of a USCIS officer. That's it. Doesn't mean approval. Okay. So when we talk about the so-called like random lottery, there has been a lot of noises out there, which kind of like mud the water. Okay. So this new rule, currently we just know the name of this new rule. It's called weighted selection process for registrants and petitioners seeking to file CAP subject H1B petitions. We don't know the text yet, okay? But we kind of have some idea that it may have something to do with the wage level. Why? Because during the first Trump administration, they published something quite similar. So they were attempting to use the wage level to determine the sequence of selection. So back then, they were proposing a rule that's going to start from the highest level of the wage, and only there are like some slots left. They're going to go to the second highest wage level, and then all the way to the entry level wage. But that rule never went into effect. It didn't really go into effect. So we didn't see that rule implemented in any of the CAP season. But it looks like something similar is coming back. However, this time it's called differently because the last time the rule was blocked by the court, okay? Because it wasn't compatible with the statute made by the Congress. So this time it sounds a little different. I'm sure David is gonna talk a little more about how this law may look different from the previous law and maybe how it might still be blocked in court. So this time it's called weighted selection. So at least personally, my guess is they might give different weight for registrations at different wage level. So last time they said they're going to start from the highest level and then all the way down, right? So which means for some of the entry level, level one, level two kind of registration, they might not have chance at all if level three or level four already consumed like all the quota. But this time looks like they're just going to give different weight to registrations with different wage level, which means it might still be a random lottery, but people with a higher wage level would have a better chance. For example, if you're at wage two, maybe you're going to be counted twice. Okay, maybe you're at wage three, you're going to be counted three times as opposed at wage level one, you're going to be only counted once. That's just my guess. We'll see what the rule actually look like when it's officially published. So it looks like they're going to still tie the chance of selection to the candidate's wage level. So that's what this rule will look like. So that's also caused a lot of anxiety among a lot of especially new grads because we know a lot of the new graduates are taking entry level positions. They might not be paid the highest level of wage just because they are new to the field. So there has been a lot of debate on this topic. That's why all of us, I encourage everybody, at least everybody at today's workshop to write your comment, okay, when the proposed rule is officially published. There's a public comment period, so you're all welcome. You can all leave comment to this new proposed rule. Okay, so this is what the H1B selection rate looks like. We can see the eligible registration is still almost like 350,000, and the actual selected registration is 120,000, which is pretty high, but still that means like maybe you get like 1/3 of the chance to be selected overall in this year's lottery. You might be wondering, here's a question. You might be wondering, wait, didn't you say the quota, like the cap was 65,000 for regular and 20,000 for master, right? Then why did USCIS select 120,000? That's way more than 85,000. Well, that's because USCIS, they based on historical data that some of the selected registration may not proceed to actual filing. Just means like some people getting selected may not end up really file the case for various reasons. Some of them maybe because the company is no longer interested in hiring the person, or sometimes there was also some discussion about some of the maybe the consulting firms maybe they registered more than they need. Okay, so for all kinds of reasons, the actual selected registration is a number much higher than 85,000. Okay. And this is what the lottery timeline looks like. So every year, the registration for the lottery would start and close in March. So it's going to be next March. But doesn't mean you start all the work next March, okay? Each company should decide who to sponsor, usually almost at the end of this year and no later than January and February, so that they can start the actual registration work in March. And we're going to know the result very soon, usually before April the 1st, because that's computer generated, right? So it's very quick. Well, we did say there are two rounds. There's a round of lottery for the regular cap. There's another round for the master cap, but that's done together. So they're not gonna do something like, oh, here's all the selected registration for under the regular cap and wait a few days. Oh, here are the selected ones under the master. No, it's gonna be all done together. You will know under which cap you're selected in the selection notice. That's how you will know, like, oh, regular cap, master cap. However, they're not gonna announce in two rounds. They're just going to announce all together by the end of March. So if you're selected, you should hear from, well, technically the attorney and the employer would hear from USCIS by logging into the portal to know who's selected and who's not. Okay. And for those selected cases, they can proceed to the actual petition filing between April the 1st and June the 30th. And then if approved, the H1B employment begins from October the 1st. So that's the timeline. The timeline should still look the same. Okay, it's just the lottery, how the lottery is run would look different. Okay, and as to the multiple selection rounds, still possible, but not always. Like say this year, we didn't see a second round of selection. Why? Because USCIS selected enough registration during the first round. As we just saw, they selected 120,000, way more than the 85,000 cap, right? So they kind of prepared for some of the registration not proceeding to the actual filing already, so they don't need to do more rounds of selections. And even there are more rounds of selection, the cap doesn't change. It's still the 85,000. It doesn't mean there are more quota for that year. It just means, oops, the USCIS maybe didn't anticipate, that many registration didn't move on to the actual filing. Okay, here's the thing, H1B wage level. What is that? That part, I think it's very confusing to a lot of the lay person, and it's also very misleading that someone paid a higher wage would mean higher wage level. Wage level is different from actual wage amount. It's actually determined by some other factors. But basically, there are four levels of wage in the government database. Okay, so you're based on some of the factors we're going to discuss very soon. We're going to divide the wage to four levels. Level one is the entry level, and level four is the highest level. So four levels of wages. And what determines the wage levels? Okay, these are the factors. Well, the person's job duties and responsibilities, right? And that would translate into something we call SOC code. Okay, so when we determine the person's wage level, what matters a lot is the actual selected SOC code, which code you belongs under. Okay, so for example, if you are working as an accountant, then your wage level would be different from, let's say, a software engineer, right? That's pretty understandable. But actually, there are a lot more nuances to it. Maybe a lot of people who don't practice immigration law won't be aware. I'm not sure if those who proposed this rule is really aware of those nuances. Because even like within the CS field, right? There are different SOC code. There's the SOC code for software developer. There's a code for computer scientist. There's a code for programmers, right? There's also code for computer system analyst. So there are different variations. They are all CS related, but the SOC code is different. And because the SOC code is different, then the wage level, corresponding to that code would also vary. So it's not really something you will know just by reading your own job duties. You probably need to also let the immigration lawyer working on your case to review that closely and decide which SOC code you belong. Okay, and then of course location matters. Okay, even that's the same SOC code. Let's say all software developers, like someone working in Silicon Valley as a software developer, the wage levels would be very different from someone maybe working in Midwest, right? So that would also matter. And also education, skills, and experience requirement. Okay, that's more to do with the employer's requirement for this position. So even for the same SOC code, same location, okay, two companies, they are filling the same position, same SOC code, they are located at the same place. But if the employer's requirement for the position is different, then it could lead to different wage level as well. So for software developer, if one company requires a bachelor's degree, the other requires, I don't know, like PhD for whatever reason, okay? So that can lead to different wage levels. And the rule is the actual wage must meet or exceed the prevailing wage, determined wage. Okay, so all these factors could affect the wage level. So a lot of the idea about higher wage level means more skilled worker is wrong. Well, first, same position at different location could mean like different wage amount, right? And or even different wage level. And also certain positions that's more complex or skilled, the starting wage is high enough. So it would be even higher to get a higher wage level within that particular SOC code, right? Like let's say a computer scientist, okay? Its starting wage is high enough as opposed to a computer programmer, right? So if you say, oh, the computer scientist wage level one is not as skilled as like a level four computer programmer. I don't think that's a fair comparison. So there's a lot of problem with associating the wage level, like a higher wage level, with more skill. I think that's like some misunderstanding. But unfortunately, this is how this proposed rule may want to work towards. And I'm going to pass the floor to Ryan and David to cover the current progress of the new proposed rule. Okay, thank you, everyone.
Absolutely. Thank you so much, Marta. And I see David has been answering a lot of live questions from the Q&A. I wanted to remind all the audiences, if you do have a questions, feel free to drop it in. And after David present, we're going to go ahead and answer all of your questions regarding H1B specifically. But without further ado, I'll let David start your side of the presentations. And he is going to talk more specifically about rulemaking process and how would that make sense and when would that make sense if it did get improved.
All right, thank you so much. So, yeah, I get to talk about the fun stuff, the rule making, sort of the sausage making, what goes on behind the scenes. So, yeah, Marta talked a lot about the substance of what's going on and what we can anticipate. I'm going to talk about the process. And before I get started, I'll introduce myself. I'm David Gluckman. I'm an immigration attorney. I'm a director of the immigration practice group at a law firm called Meng Holton. We represent students and their employers across the country and across the world. We represent lots of the largest institutions in the United States, so colleges, universities. So we deal with this stuff all the time. We're really plugged in, and we're certainly waiting with bated breath for this rule to be released so we can know how to advise people. So before we get started, I mean, we already went over this. There's potential new lottery. Is it in place yet? No, not yet. It's got to go through the formal rulemaking process, which is established by a really fun statute called the Administrative Procedure Act. And if anyone's ever having any problems getting to sleep, I certainly recommend you take a look at the APA because I'm pretty sure that by the third or fourth subsection, you'll be fast asleep. So I don't want to have you go through that APA and have to do that. So we're going to go ahead and summarize that today. So the lottery is governed by something called a regulation. Okay, so we're not talking about a statute, we're talking about a regulation. So it's one level below a statute. Changing a regulation requires a formal process called rulemaking. So that's what we saw today with respect to that new F1 rule that's going to be published tomorrow. It's also the same with respect to this H1B rule that's going to be published probably very soon. So the first step is that the government decides that they want to do something. So a new public policy initiative, and then behind the scenes, they draft this rule. So they go through their own lawyers. They talk to certain practitioners. Certainly, they didn't talk to me about this, but I don't know who they did, but they do solicit some different inputs, and then they put together a proposal. Okay, and they receive clearance. They review that, and then Then they publish it to the public. Once that proposal is published, then the public will have usually a 30 or 60-day period to comment on the proposal. So most of the time it's 30 days. And it's relatively easy to submit these public comments. You can go on to the website called regulations.gov and you just type in the rulemaking number and then you enter your comment. And I urge, like Marta said, everybody to get involved in the rulemaking process, make your voices heard. I'm not kidding when I say that one person can make a difference. There was a rulemaking about H1Bs about 10 years ago that I thought was under-inclusive. And I, on my lunch break, just typed in a quick comment. I happened to be the only person that submitted that comment. And that comment actually ended up changing the text of the final rule. And the person who was working on the rulemaking process after they left government, they called me and told me that my comment actually did change the law. So don't sit on the sidelines and feel hopeless. Go ahead and participate in this comment process. All right. So during this 30-day comment process, when the public comments, that's going to close. And then the agency is going to have to analyze all the feedback and the public comments that are received. This is the sort of unpredictable part of the process in terms of length. So, I'm anticipating that for this actual rule, there are going to be tens of thousands of comments that are going to be received. So they're going to need to review all of them. They don't need to answer every single one of them, but they do need to substantively address most of them. And that's going to take quite some time. So, we really can't predict how long it's going to take between when the public comment period closes and when the actual final rule is published. So after they do that after they do that review of the public comments, then they need to address the comments, and then they'll make, or they might not make any changes to the final rule, and the final rule will be published. and it will generally take effect 30 to 60 days after that is done. Okay. So the question is, okay, so this looks like it's going to take many, many months, but can it be done if it's started now in time to take effect for the 2026 H1B lottery? Well, as Marta said, the lottery is going to be weighted based on wage levels 1 through 4. And so the easiest way to look at whether or not we think this is going to be published in time is to look at what happened the last time in terms of the time frame when prior Trump administration proposed a similar rule that would base the lottery on wage levels. That proposal was published on November 2nd, 2020, so right before, I think it was the day before the 2020 election. And that had a 30-day comment period that ended on December 2nd, 2020. So, okay. And the final rule ended up being published on January 8th, 2021. So they only took about a month to review all those comments. All right. And then that rule was going to take effect 60 days later on March 9th, 2021. So, in other words, in time to take effect for the 2021 lottery. Now, once Biden won the election, he got sworn into office. He decided to withdraw that rule. So it never really took effect because they said it conflicted with the statute. And like Marta said, it was going to disadvantage entry-level workers. A lot of folks who are coming right off of their OPT and into level 1 positions, they would be prejudiced by this rule. But the bottom line is, look at this timeline. It only took them a few months to ram this through. So even if they start in August, see, they started in November before. So if they start even earlier in August, there's definitely going to be enough time for them to get this in place for the 2026 H1B lottery. Now, as we were discussing earlier, can this rule be stopped? And I think that definitely can, at least maybe temporarily. I mean, you can certainly expect litigation. There was litigation last time. And the real crux of it is that there is a statute. Remember, I told you statute is number one, regulation is number two. So the regulation cannot conflict with the statute. Well, the statute says that the allocation of H-1B visas shall be determined by random selection. So that shall is probably the most mandatory and unequivocal term in the law. So they can't make anything other than a random selection. So if you're starting to take into account wage levels, then guess what? That's not random anymore. You're considering various factors. So it would seem to me that this would conflict with the statute and is certainly vulnerable to potential litigation. Now, you might be asking, oh my gosh, what about that Supreme Court decision in June where they said there are no more nationwide injunctions? Do we have to go court by court in every single state to stop this? Well, fortunately, that's not the case with respect to, remember our friend, the Administrative Procedure Act, because there is a provision in the Administrative Procedure Act that allows for a nationwide vacatur. So to vacate, meaning to nullify the rule, and it can take nationwide effect. Okay. So if somebody in any court files a lawsuit and the judge says that it conflicts with the statute, then they can enjoin, meaning they can prevent this law, this regulation from taking effect for the 2026 lottery while they continue to litigate whether or not it is legal. So it really is, it remains to be seen. Obviously, we don't see the text yet, but I would imagine that there are a lot of lawyers that are out there with their pencils sharpened, ready to litigate this. And we already have a roadmap from before because it was successfully litigated, I believe, in the Northern District of California. So in the San Francisco federal court back in 2020 and 2021, they're going to be able to reuse the same arguments and hopefully get a similar positive result for everybody. And again, there are also a couple of other things they could do is class action lawsuits could still be viable. For example, if a bunch of universities want to band together and say that this prejudices their graduates who are trying to enter the workforce, that could be potentially another way of attacking. And then a lot of what's going on now, since it's so political, individual state attorneys general might want to take a stake in this and say, like, hey, if I'm from Massachusetts or I'm the California Attorney General and I want to file a lawsuit, then they might be able to get this enjoined nationwide without anyone else having to participate. So there's no shortage of potential litigants here. I fully expect that there's going to be a lot of action here. So even if the rule is published, don't lose hope because there is still a very good chance that this rule can be delayed at least for this particular cap season. But that really highlights the fact that if you have an H-1B employer and you've got maybe a level 1 wage, this is the year to get in the lottery. don't wait because this could be your last chance. I mean, if this lottery litigation is ultimately unsuccessful and it takes effect the following year and you didn't participate in the lottery in 2026, then your chances are going to be very minimal of being selected. So we do these types of filings all the time. If you have an H-1B employer, you can certainly put them in touch with us and we can get you guys into the lottery and hopefully selected and approved. So I've got my contact information here. But now I'm going to open it up for questions, but hopefully you guys understand a little bit more of the process and where we go from here.
Absolutely. Thank you so much, David and Marta, for your wonderful presentations. And then we wanted to dive right into the Q&A sessions where people ask a lot of questions. I see you already answered part of the questions from David, but for everybody who's still sending in questions at the moment, make sure you take a look at other people's questions. If that questions apply to your question, sure to give them the upvote a thumbs up so that we can know how to prioritize when to answer which questions. But I'm gonna proceed with the first question that I see which has one upvote at the moment from Ray. This question is saying that for H1B extension, for somebody who already has an H1B, right? Does the wage must meet level 2 prevailing wage or level 1 wage is fine for an extension? I think this is slightly, not directly relevant to the lottery itself, but this person wanted to ask more about the H1B extension.
Yeah, I mean, I can answer that if you want. I mean, it really depends on what the particular position is. I mean, think about it. For various types of careers, you're going to be at level 1 for a long time. Like if you're a doctor, if you're a resident physician, you're going to be level 1 for a very long time because you're going to be getting supervision from the higher ups to make sure that you learn everything. Same thing with an attorney. I mean, I can tell you from when I practiced law at the beginning of my career, I was probably a level 1 for like at least 5, 6, 7, 8 years because you're learning so much at that level. So yeah, it really depends on the actual position, the duties you're doing. But with regard to this lottery rule, it's not going to affect you because if you've already been selected and you're applying to extend, then you don't need to go through the lottery again. So you'll be able to be there to console some of your friends that have to go through it the first time. But if you're already counted in the lottery and you're looking to extend, it's not going to affect you.
Absolutely.
Right.
Anything to add, Marta?
Yeah, I agree. This has nothing to do with this new rule about the lottery. But we did get that kind of question from some of the students. Like, does that mean I have to have certain amount of wage increase over the years? Would I get into trouble if I like say my wage doesn't increase as much, to kind of to the next level? No, not at all. As David, it's very common for certain positions to be in level 1 for a long time. Also, remember the wage level really has more to do with your employer's requirement for the
Yeah.
position. So if your employer's requirement for the position doesn't change, then your wage level wouldn't change either.
Absolutely. Thank you both. All right, we see a couple of upvote. That's good. Guys, keep that coming. And if you have a new question, feel free to drop that in. Next question from another audience. What are the proposed changes to the F1 visa? Oh, now we're already at F1. I know we were talking about H1B, but that was such a big news with F1 and everything might be changing in the future. And then also day one CPT, for example, if there's anything related to day one CPT. So I want to ask both of you. I'm going to start with Marta this time. The proposed rules, some parts of the proposed rules comes out with F1 today. So what's your take on the new proposal?
Yeah, first of all, I want to mention this proposed rule on F1 is still a proposed rule. So just like David mentioned earlier about making comments to the H1B rule, you can make comments to this proposed F1 rule as well. Something you find unreasonable, you can share some comment. That may affect the final rule. To be honest, I haven't got around to read the full text of that rule yet, and I know the final copy of the proposed rule will be published tomorrow, the 28th. There can still be some last minute change between the copy today and the copy they're going to release tomorrow. Some of the changes that I am aware right now, first is going to be the fixed period of authorized day for F1 student. Like say for a lot of the F1 student, like your I-94 would show D/S, which means duration of status. You don't have like a fixed end date of your stay in the US. That's gonna be determined by your CVIS record, right? Like your program end date. And when you change from program to program, you don't have to go through USCIS. You don't have to file anything with USCIS, but that's gonna change. Okay, you're gonna have a fixed time for your F1 status. And when you want to enroll in another program, you have to file an application with USCIS. So that's going to be a big change. And some of the other proposed changes so far I've seen include like they might want to bar like having like multiple degrees like at the same level or maybe at a lower level. I haven't got around to read the full text yet. I will take some time and maybe we're going to have another workshop. So that's some of the changes that I have seen so far.
Yeah, how about you, David?
Yeah, I mean, I looked at it and I mean, I'm not going to sugarcoat it. It's pretty devastating. I mean, the stuff is really, really bad, especially with respect to people who are, you know, in programs so that they can continue to get work authorization because they're shut out of our other immigration options, which are artificially limited. Um, First of all, they're saying that there's a presumptive 4-year maximum period of F1 status. I mean, that's definitely not long enough for a lot of degree programs, especially PhDs. And anybody who wants to extend beyond that is going to need to file an application with USCIS and meet a lot of requirements. Like Marta mentioned, they're only going to allow you to enroll in new programs that are at a higher degree level. So that's basically saying no more second masters, no more third masters. You got to go from master's or PhD, and that's the only way you're going to extend. So, and they're going to shorten the grace period after graduation to 30 days. It's currently 60. So there's a lot of horrible stuff in there. Again, like we've been advocating, make sure that you make your voices heard. I mean, this is really going to be devastating to higher education. And unlike the rules we're talking about with the H1B, I really think it's going to be more difficult to stop this one in litigation because there's no statute that really forecloses what they're trying to do. Because really the F1 and J1 status are the only carve-outs to get duration of status as opposed to fixed periods. So what the government's saying is that they're just bringing those statuses in line with everybody else. And, it's just really not a good thing. And again, make your voices heard. I hope I'm wrong, and I hope it is stopped, but we really need to lean on not only ourselves, but make sure that your administrators at your universities are aware. I mean, that's going to be a more authoritative comment if it's coming from like the president of university than from an individual student. So if you guys can band together and other advocacy groups as well, then hopefully we can get at least some changes to this rule. I think at the very least, maybe we can get the 4-year period extended to 7 or 8 years. But other than that, even if you have to apply for OPT, that means that you have a bachelor's degree. Well, that's 4 years, and if you want to stay extra for that 5th year of OPT, you're not only going to have to apply for OPT, you're also going to have to submit an extension of stay application. And it's just a real shakedown in terms of filing fees. It's going to lead to more backlogs in terms of immigration processing applications. I don't see anything good for this, but these are some of the things that need to be pointed out in comments so that they can hopefully reverse some of these things.
Thank you so much. I think a lot of the audiences are currently under the F1 visa, so there is a lot of uncertainty at the moment. So we will keep sharing all the information that we get and keep hosting sessions like this so we can get you prepared. Moving forward, let me just refresh the upvotes. Some new questions coming in. The next one is more about back to the F1, the H1B lottery. So will it going to be a lottery system that for the upcoming year? I guess the questions would more be depending on will it be a changed H1B lottery system for the H1B year? Would that be how likely would that be if the H1B lottery is going to change?
Well, like I mentioned, I think that there's a good chance they can get the rule through in time for the lottery, but I also think there's an equally good chance that it's going to be stopped in litigation. So it's anybody's guess right now, but my prediction is that it will be stopped at least for this year. So that's why, like I said, I advocated that if you have an employer that is willing to do you an H1B, then get in the lottery this year before any of these changes take place in the following year.
Absolutely. All right. So Next question is not directly related to the lottery. This person wanted to know, what if I don't have an employer at the moment, but I want an H1B visa. I wanted to join the lottery. What would be some of the options that the person have?
You need an employer.
Yeah,
You
I
can't
mean,
file your, yeah.
H1B is petitioned by the employer. So you would have to have an employer. I know this year, the new H1B modernization rule allow beneficiary-owned H1B entities to petition for that beneficiary. But that doesn't mean you can self-petition. I don't think that's a very accurate term to say you're self-petition. You still need an entity. And you also still need to prove there is a bona fide job offer. You cannot just have a shell company and claiming this company is going to give you a position. You have to show, what kind of business this company will be engaged in and why the business needs such a position that you're currently petitioning for, right? So that's another option. I think this is actually very good news for those students who want to do some work for themselves. They want to start a business, they want to be entrepreneur, but just be mindful, you still need to show there's bona fide job offer.
Absolutely. And then before we proceed to the next question, I wanted to let everybody in the audiences know that there is two functions down below. You will see the chat box and you will also see the Q&A box. So when you are asking a question, make sure that you send that into the Q&A so everybody could see your questions and then your fellow could also upvote your questions. So that gets the question answered in the first order. All right. So moving forward, let's see. All right, next question. This person also wanted to learn a little bit about starting up company or owner of a company's ability to sponsor H1B or sponsor any other work visas. Has those regulations changes in terms of how I could self-sponsor potentially for any work visas?
Well, like Marta said, I mean, they liberalized the rule last year so that now you can, a company you own can sponsor you for H1B. But like she said, it can't just be a paper tiger. Remember, there are wage obligations. So if you're required to pay at least a level one wage, and let's say it's $60,000 a year, then you got to be able to show that the company is existent and is able to pay that wage, right? And you also have to show that it's a bona fide job offer, not that you're just going to be, whiling away the days in your dorm room, just, having fun playing Minesweeper. No, you got to be able to show that you're using at least a bachelor's degree to perform the duties of the position, and you're going to be spending at least half of the time doing that. So it can't be about going out and making sales calls, going on the road, designing a website. No, you got to make some specific connection between your degree program and the startup that you're doing and show that it's a bona fide job offer. So you're typically going to need to have a business plan. You're going to have to show that you can finance the way that the wages are paid. So yeah, it's not just a matter of checking a box and filing a petition. You actually have to have a lot of good underlying evidence because these petitions are very heavily scrutinized. They were scrutinized before. They're even going to be more scrutinized under the Trump administration. So it's certainly an option if you have a viable opportunity. And a lot of people take their time on OPT and STEM OPT to build up a business, right? Well, you can't really do a startup on STEM, but you can use OPT to build up a business to a point where it can be a viable sponsor for the H-1B.
Absolutely. All right. Moving forward from this question, next question, I think this question actually is a great question. So, is the H1B proposal or regarding the salary, will be based on the county where I lived in or where my company offices is located at?
So I'm gonna be talking about like generally how wage levels are determined. That's based on the work location. So not where the company's headquartered, but where you are working from.
Right.
Okay, sounds good. Let me just do a quick refresh. Okay, next question, also very important. This person wanted to know how can we participate in the commenting process if anyone that hasn't done that before.
Yeah, I mean, like I mentioned in my presentation portion, you go on the website regulations.gov and you follow the instructions to submit a comment. All you need to do is have the actual rulemaking number, and that's going to be on the proposal at the very top. And then you just have a box where you type in the subject line of your comment and you just type your comment into the actual box hit submit, and your voice has been heard. It's pretty easy. They've done a good job of facilitating public participation in the rulemaking process by doing that through the website.
Okay, thank you so much. That was very detailed, David. All right, moving forward. Next questions, Pavan wanted to ask, do the F1 visa restriction, which is also one of the proposals, will impact students who are already in the USA?
Yeah, I mean, I like I said, I've skimmed the rule, and there is a grandfathering, so to speak, of people who are already here in duration of status. And my understanding is that that will continue to be the case. However, if you travel outside the US, you're then going to be subject to the new rules.
Okay, sounds good. Next question, this person is coming from a day one CPT background. So if somebody is on day one CPT at the moment, what will potentially be some of the changes with the F1 proposal going on for day one CPT program?
Well, if you're in a day one CPT program now, I don't think there's going to be any particular change unless you decide to travel. But going forward, um, if your day one CPT happens to be a second degree that you're getting at the same level, so for example, you already have a master's and you're getting a second master's, under the new rule, that's not going to be an option. So you'd have to go enroll in a PhD program that offers day one CPT. But yeah, definitely, if that's something that may impact your career path and you have particular concerns that you think they might not have considered, then you absolutely should go ahead and submit a comment and make your voice heard. And also for the benefits for everybody else in the day one CPT community. I mean, I think that you guys need to band together and articulate to the government exactly why it's so valuable for this to be able to continue. I mean, we really have a highly skilled workforce. Think about it. People who are on day one CPT, even if there is a weighted lottery based on wage level, you guys are probably going to be privileged because the vast majority of day one CPT workers are already pretty far along in their careers. They're going to have level two, level three, level four jobs. So you guys are a very highly skilled cohort of the population. So if this weighted rule comes in, then you may have a better chance of getting selected in the lottery. But if it doesn't, you certainly need to make your voices heard so they can understand the value of being able to continue to provide this practice-based education, which for some reason it's okay for Americans to do, but it's not okay for anyone else to do. That just doesn't make sense.
Sounds good. All right, moving on. Next question also from Pavan. So he wanted to ask, what does it mean by the public to comment? Any particular things that should or should not be said? Like for example, for the F1 visa, can I put in my own concerns or it should be based in facts or rules or understanding of a regulation?
Well, I mean, you can say anything you want in the comment. That's what's so nice about it. But if you have a particular concern with the legality of it, and I think that probably be the strongest reason to comment, because the last thing the government wants to do is to invite a lawsuit because they've overlooked a particular statute or provision of the law. But you generally we're going to rely on lawyers to submit those kinds of comments. So for you, I think it would be more illustrative or more persuasive to discuss your particular situation. Because remember, these people are bureaucrats. They're just sitting in a building in Washington, D.C. They don't understand for the vast majority of what people's experiences are day to day. So if you can bring to them the effect of what this rule would do on your day-to-day life, the day-to-day lives of your community and your university, I think that would be very illustrative. But in terms of format, substance, there's no specific formatting requirement. There's no specific substantive requirement. Just say what you think is going to be the most persuasive. And again, they're going to see your comment, and they may indeed address it in the final rulemaking. But if you stay silent, then really you have no chance of participating and getting the rule changed.
Yeah, I mean, lawyers will comment, as David mentioned before. He commented in some of the previously published proposed rule, like I previously published proposed rules as well, and they do address it. So in the final rule, they're going to address each of the comments. So you will see that they might not name you, but they are going to say, an organization, a law firm, or an individual commented on this. So they're going to read and address each one of them. So at least for a lot of you, I know you may be pursuing your second master, let's say. Maybe you want to comment why you want to pursue a second master, right? Like there's a legitimate reason for that. It's not because you want to stay in the US, but you have some like a genuine academic reason to
Right.
pursue a second master. So that would be something good to put into the comment, just speaking from your own experience.
Exactly.
Yes, I see it as a very common thing for actually for second master, even for US citizens. For example, somebody who were in a technical position and wanted to pivot into management, somebody will get an
MBA.
MBA.
Yeah.
That's 100%. So definitely let your voice heard when it comes to a proposal like this. All right, moving forward, I want to remind the audiences. I see lots of questions, over 100 questions that we obviously couldn't answer them all for you. But could you just take a couple seconds for each audience's view to take a look at questions around your own questions? If you see something aligned with what you wanted to be answered, just click a little thumbs up so it gets to us a little faster so we can answer the questions for the majority of the audiences. All right, I'm gonna hit on refresh, and then we're gonna proceed with the next questions. So this one is from Redica, is a little bit more related to the F1 side of the thing. So I have a one question which is not really about the lotteries, but can we travel outside of the countries on F1 visa ending in 2026? Which is an assume, which this person has an F1 visa, that the F1 visa is going to expire. Is it right now a good time for them to travel, or what if they do travel? What is advisable for them?
Um, I mean, generally speaking, I would say most immigration attorneys advise clients to avoid international travel if possible at this moment. I mean, but I understand, sometimes you may have some emergencies that you have to take care, but it's very hard to answer this question because it has a lot to do with your personal status history. So I would have to caution you, you do need to factor a lot of things when you are planning an international trip. It's not like you cannot travel at all, no matter how urgent you have like something overseas. But I don't think anybody can just tell you, oh, it's okay to travel and it's going to be safe, because there's a lot of certainties out there.
Yeah, make an appointment with your campus advisor, discuss the circumstances of your travel, make sure that you have the documents that you need in terms of the I-20 and everything. But keep your eye on this F1 rule because if there's a choice between traveling now and traveling later after that F1 rule takes effect, and you can possibly meet the requirements of reentry either way. I would certainly recommend traveling and re-entering before that rule takes effect, because then otherwise you would be subject to that 4-year limitation as opposed to getting duration of status. So certainly keep your eyes on that.
Mhm. Absolutely. All right, thank you both so much. And then moving forward, another question about the commenting process. People are really proactive into
Good. Yeah.
submitting that. So, are comments going to be anonymous, or is there any risk of submitting something maybe critical, maybe regarding certain concerns coming from a international student? And I get this question because we already have the social media vetting that, that supposedly that people are watching what you said
Oh,
on the
yeah.
internet. So how do you guys think about that?
Well, first of all, you can submit the comment anonymously or pseudonymously. So you can use a pseudonym. Say, I'm John Doe, and I'm enrolled at Harrisburg University in a second master's program, and I want to let you know about this. There's no reason that would be a problem. And then, like Marta said, when they actually do address the comments, they're not going to name the individual commenters. They'll say like one commenter said this, another commenter said that. The only commenters they might necessarily name are some of the larger organizations that are publicly known, but there's no real concern of being unmasked in the final comment publication because they're not going to use your name.
Right. And also about this social media post. Well, I mean, this is a proposed rule, and they are inviting public comments because, this is not a final rule yet, and the government is inviting comments. So I don't think any comment on this proposed rule would be perceived negatively in your future application because that's like a free comment stage. So that's how I look at it.
Okay, absolutely. All right. Due to the timing perspective, we're already running out of time. So I'm gonna answer one last questions. Uh, in terms of the audiences, a lot of people wanted to ask, will both of your firms be able to assist something beyond H1B, for example, like O1, EB1, EB2, or L1 visa as mentioned, and then maybe you guys could share how could people contact you, and then they can proceed with those kind of consultations.
Yeah, sure. I mean, I do those kinds of cases all the time. I mean, if you have an employer, then you can put them in touch with me and we'll work it out. I mean, I do L1s on a daily basis, O1s, everything. In terms of the green card process, unfortunately, due to statutory backlogs, those are taking a very long period of time. We certainly do them, but you're definitely going to want to focus on having a long-term non-immigrant status like O1, H1B, L1 to keep you here living and working while you go through that multi-year process. And I'm sure Marta is also the same.
That's right. So we do all kinds of employment-based petitions, also work visas. So feel free to send me your information and we'd be happy to evaluate your case.
Yeah,
Mhm,
and I think
absolutely.
you can reach out by email. I think our emails are on the presentations. Yeah.
Yeah, I already shared. I also shared both of your emails in the chat in case anybody needed, or if you have a follow-up questions also. And then also, I wanted to thank both of the attorneys, Marta and David, for today's wonderful sessions. We learned so much about H1B. We were initially just going to talk about H1B, but then also this H1B this F1 new proposal came down, and then I'm glad that we touched on so much information. And I wanted to keep touching on those information because lots of people joining today are under F1, and this is really, really crucial for a lot of us. So for those of you who miss parts of the sessions, don't worry, we'll send an email to you with the whole recordings. We're also going to produce videos from today's sessions, be posted on GoLee's official channel. So we will make highlights. Feel free to watch them as well. And thank you so much for Marta and David again for joining us. I know it's pretty late from where you are, David, but thank you so much for your participation, for your insights. And I look forward to do another session with both of you.
Thank you
Okay.
for
Yeah. Thanks,
having me.
Robin. Thank you to Go Elite and keep on keeping on, everyone. Don't lose hope. Make your voices heard.
All right.
Yeah,
Thank you.
thank you.
All
Okay.
right.
Take
Bye.
Thank you.
care.
All right. Thank you, everyone. I'll see you soon.